Hi, everyone. Thanks for joining us. My name is Mia Evans. I'm an Engagement and Mobilization Associate at the National Women's Law Center, and you've joined Representing Pregnant and Parenting Students Facing Discrimination at School. Thank you so much for joining us. We have just a few technical notes before we begin the presentation. All lines will be on mute during today's webinar. We will be taking questions after our presenters are finished, but we encourage you to submit questions throughout the webinar. You can submit a question by typing it into the designated area on your control panel and hitting send. As a reminder, we will be sharing the presentation with you by email after the webinar. Before we start, excuse me, we will be recording the presentation and we will share it by email. I'm about to turn it over to Alexandra Brodsky, our fellow at the National Women's Law Center. Alexandra, take it away.
Hi, everyone. This is Alexandra. I'm a legal fellow here on our education team, and we're so thrilled to have you join us and to have our really wonderful presenters. As many of you already know, a really unacceptable number of students in middle school, high school, and higher ed face discrimination because they are pregnant or because they're a parent or for related conditions like abortion, their plans to seek an abortion. And unfortunately, there are very few lawyers who feel confident taking on these cases. So many students go unsupported and their educations are interrupted as a result. So we are so excited that you decided to join us, and I'll have some thoughts at the end about how you can link up with us to help us support these students. But first, I want to introduce our really wonderful presenters. So we're going to be learning from Kelly Garcia and Galen Sherwin. Kelly is senior counsel here at the National Women's Law Center. She actually first came to us in 2009 as a law fellow and then returned about 5 years ago as counsel. She has a PhD in social psychology from UCLA and a law degree from Yale Law School. We're also joined by Galen Sherwin, who is a senior staff attorney at the Women's Rights Project of the ACLU, founded by the notorious RBG. She focuses on gender equality in education and has represented students on facing a number of forms of gender discrimination, including discrimination based on pregnancy and parenthood. And she is a graduate of Columbia Law School. So they're going to take it from here, and we look forward to your questions at the end of the presentation. Kelly and Galen, take it away.
Thanks, Alexandra. Can we go to the next slide? So I apologize, we're gonna have a little bit of next sliding today, but I hope the presentation will go really smoothly. Before we get started, I did want to say just a little bit about the National Women's Law Center. We have been working on behalf of women and girls for 45 years, since 1972, and our goal is really to ensure that women and girls have the resources necessary to achieve their potential throughout their lives, and that's really at school, at work, at home, and in their communities. And so we really see, at least for me, this work on pregnant and parenting students in particular as an extension of this. This is about ensuring that young parents are able to achieve their full potential. And in order to do that, we really work and use the tools that we have available to us through Title IX and through state laws as well. And so today, can we go to the next slide? Today I want to start talking about, today I want to go over a little bit about what Title IX covers and what schools' obligations are really under Title IX. I do presentations, I do a fair number of presentations to kind of schools and advocates, and a lot of people don't realize that Title IX actually protects pregnant and parenting students, and even if they know that it reaches pregnant and parenting students, they don't necessarily know kind of what the scope is. So I want to kind of make sure we have that basic background. And then I want to go over just a handful of examples of discrimination, the kinds of things you might encounter and you might hear if you're thinking about representing students, the kinds of things that you might see or really be on the lookout for, because again, some of the things that we see that really are discrimination or are violations of Title IX you might not realize that kind of at first blush. So we want to make sure that's really clear. And then I want to talk a little bit about working specifically with I want to talk a little bit about working specifically with schools. Sorry, it looks like my slides got a little bit switched up. So the second button there should be negotiating with schools. So we're going to talk a bit about working with and supporting your students, supporting your clients, and how you're going to do that in talking with the schools. Can we do the next slide? So Title IX really prohibits discrimination on the basis of sex in any education program that receives federal funding. So that's going to reach the majority of schools. And it's going to reach the majority of schools, but can also reach other education programs that aren't necessarily schools. So if it's an education program and it receives federal financial assistance, then it's covered by Title IX. And so there have been specific regulations issued by the U.S. Department of Education on talking about the treatment of pregnant and parenting students. And at the back of my slides, there's a link, and when the slides are emailed out, you'll have that link to what that guidance is. In general, we think, at least from the National Women's Law Center's perspective, we work a lot, we have in the past always worked with and tried in terms of getting enforcement through the Department of Education's Office for Civil Rights. Kind of as we go through my presentation, I'll talk a little bit about whether that is a good strategy or the strategy that we want to continue to follow. What's not there is if there's a private right of action and there's no requirement for exhaustion of administrative remedies. Go ahead, that was the next slide. So schools are really prohibited from discriminating because of pregnancy, childbirth, false pregnancy, termination of pregnancy, and recovery from any of these. And this applies to academics, it applies to your school programs, it also applies to extracurricular activities. And schools, what this means is that schools must treat students affected by pregnancy and related medical conditions the same as similarly affected of students who are similarly affected by temporary disabilities, and they must excuse all pregnancy-related absences for as long as medically necessary. And I'll talk a little bit more about this, but this is one of the key pieces where there's a real problem in terms of students not getting the kinds of accommodations that they really need. Can we do the next slide? Yeah. So sorry, the slides kind of got messed up, but so New Mexico had a past and attendance policy, which I'm not going to talk about right now, but we have, but to be clear, Title IX's requirements are, that you have to excuse all pregnancy-related absences for as long as medically necessary. And this is one of the things that's a little different. So it's not, when we talk about the absences are not that you need to have, that's all pregnancy-related absences have to be excused, not just that if you would excuse them for similarly situated, for somebody who had a similar disability or in their ability to attend school. All pregnancy-related absences must be excused. In addition to this, we need to have access to special services available to students with temporary disabilities. So we're going to pause just a second to try to get the right slides up. I apologize for this. Did my screen just show?
Kelly, your screen is up. Mm-hmm.
My screen is up? Okay, perfect, thanks. Okay, so returning after absences. So at the end of the leave period, a student must be returned to the status she held before the leave period started. The student must also, and again, this is really key and something to watch out for when you're working and talking with students who are having a hard time, who are experiencing discrimination because they are pregnant or parenting, students must be given reasonable opportunities to make up missed work while they are on leave. And again, this is really key. If grading is based in part on class attendance or participation, the school has to come up with a way for the students to be able to make that up. They cannot say that we're going to kick the student can't participate in that class. The school can't say that the student is going to be penalized because they miss parts of the class. No, it's really on the schools. It's part of the school's responsibility to come up with a way for the students to be able to make up that piece. This is something we see in kind of secondary school, but we see a lot of people saying, well, this is class participation, and so there's nothing we can do if you're pregnant, you're just going to have to drop out. We see that from schools a lot when we talk about kind of professional schools, colleges, nursing schools in particular, for some reason, have a really hard time with this piece. So it's really important to keep in mind when you're talking with your students, because a lot of times, at least it's been my experience, when we're doing intake or working with students, is that they'll focus on that part might have seemed reasonable to them, and so that won't be something that they're focusing on when they're coming to you with these problems. So talk about classes and school activities. So schools have to allow pregnant and parenting students to continue participating in their classes and their extracurricular activities. They can't tell a student, they can't tell a student just because you're pregnant you have to drop out. Particularly sports, again, this is something we see as a student gets pregnant and they're told, oh, now you can't participate in this sport, or you can only participate in the sport if you have a doctor's note. But again, you can't treat the students differently because of their pregnancy, and so you can only require kind of a doctor's notice. That's really what you would require from everyone else. And again, this is a place where we see a lot of non-compliance and a lot of non-compliance with Title IX, where schools think that they're doing the right thing. The person, the coach might think, oh, this student's pregnant and I want to make sure she's safe. And so this is a place for real education and a place where, you can come in and talk with a school and have an opportunity often to fix some of those problems. Special instructional programs or classes for pregnant and parenting students have to be voluntary. Again, if a student is pregnant or parenting, the school can't automatically push them off or say, go, push them into these other programs, even if they have some really good programs. There are schools like New Mexico, where I have the wrong slides up. There are schools like places like New Mexico that have really great programs for pregnant and parenting students, but they cannot be forced into those programs. And there are also schools that have some really, really terrible programs that don't educate and are really kind of just holding places for students. And we want to make sure that pregnant and parenting students aren't forced into those. And schools need to be, maybe required to make reasonable adjustments for students. So they need to kind of make accommodations for pregnant and parenting students that they would make, again, for kind of a similarly, someone who's similarly affected by a temporary disability. So if they would allow the student to have a larger desk, then a pregnant parenting student would need or a pregnant student would need to have a larger desk, or maybe an elevator pass if she's having a hard time getting up the stairs. And we've definitely had some cases where elevator passes, for example, were really big issues because girls were were suffering injuries, or having a hard time navigating the stairs, or had stairs that were just particularly challenging. And so those kinds of things, again, to be on the lookout for. And that might not be if a student's coming to you with some concerns where there's something really blatant, like they're being pushed off into another program. They might not, they might also have some of these other pieces that would need accommodations that are a little smaller. So when you're talking to your clients or your potential clients, you want to make sure that you're asking for that full range of things. So clubs and sports. So you can't exclude a pregnant student from any extracurricular activity of any kind just because they're pregnant, which I kind of already said. Pregnant students also must be eligible to participate in the same leadership positions, the same types of honor societies. Schools cannot say that the student can't receive an honor because she's pregnant. They can't say you can't go on this trip because you're pregnant. None of those things. They cannot be excluded. And this is true even if the activity is not operated directly by the school. So the school has the responsibility that the things that are taking place on its campus must be in compliance with Title IX as well. So again, something you might not, something that might not have come up immediately when you're talking with your student, with your potential clients, but something to kind of be on the lookout for. So harassment, and this, I didn't kind of say this at the beginning, but we have recently done some research, in particular a survey and focus groups that included pregnant and parenting students. And one of the things we found is that girls were really talking about, particularly pregnant and parenting girls, were really talking about and experiencing a lot of problems with harassment, with teacher harassment because they were pregnant, with harassment because of from other students. And schools have an affirmative duty to protect their students from these kinds of problems and from harassment. So our examples of discrimination tend to fall, and I've said 4 categories. After we've done this research, I feel like it's maybe a little more than that, but this is kind of how we've broken it down for now. An environment of discouragement, a refusal to accommodate, inaccessible homebound services, and an unequal alternative. So for the environment of discouragement, we really see from schools kind of a lack of guidance or support when students find out they're pregnant. When schools find out students are pregnant, there can often be just a kind of writing that student off, kind of shepherding them into other schools. Teachers, they might feel like their teachers have given up on them. That's a violation of Title IX, and it's a problem, and it's something that you can help address. There's also just the active hostility at schools. Girls can feel from their teachers, from administrators, that they just shouldn't be there at the school. And that's, again, one of the things in our recent survey that we found, girls reporting, pregnant girls reporting that their teachers, that people did not want them at the school. And then there's also a real problem with a rigid application of schools, a rigid application of rules. So for example, if a pregnant student outgrows her uniform, one of the places where we see problems is students getting expelled because, or suspended or told not to come to school because they don't have their uniform, but they don't fit into their uniform anymore. And so there needs to be those kinds of accommodations. So unequal alternatives. So the first example here is this New York City P school, which was shut down in 2007, but it's a really extreme example of a school for pregnant and parenting students where there was virtually no education. They did knitting as their math work. It was just a really awful school, and you can spot those schools. I think when you see them, it's very clear that they're very problematic. What's a little harder, I think, to see is that girls might also be kind of being pushed into online schools or kind of alternative schools, like, oh, here's a vocational school that's helpful for you. But any school that doesn't have the full rigorous opportunities to learn that you would be able to get at their home school is in violation of Title IX. Schools girls are being forced into those schools or pushed into those schools. Another thing we see a lot of, again, from people who I think are genuinely trying to be helpful, are girls that are, when they find out their student is pregnant, they try to encourage them to go to these kind of other schools where there's childcare. Again, often the childcare is not in a fully rigorous school. It might be a slightly more vocational school or kind of an alternative school. It might not be the fully as academically based as the student's home school or where the student wants to be. And also, it just might not be a fit. Yes, there might be childcare at that school, but there might not, transportation might be a real challenge, which again, is one of the things we've seen kind of in our surveys as the problems that pregnant and parenting students face in terms of transportation. And so any kind of trying to push students off into schools, into a kind of a set of schools that are not as academically rigorous, don't provide provide the same learning opportunities can be a real violation of Title IX. And again, something you want to watch out for, and something that can sometimes be more easily resolved, because once people realize what they're doing, they might be willing to kind of change it more quickly. So another place where we see discrimination is inaccessible homebound instruction. Pregnant, and if the school has a homebound instruction, then pregnant and parenting students need to be eligible and need to be able to access that homebound instruction, and they need to get the same types of information about that instruction. And a lot of times, again, there can be real barriers for students who are pregnant and parenting that just aren't there for students with a similar with a kind of temporary disability, and you need to be on the lookout to make sure that there aren't kind of extra barriers being put in the way of ability to access homebound instruction. So I have this little slide in here on breastfeeding. So breastfeeding or lactation, is really a pregnancy-related medical condition, and it should be covered. So pregnant students, so if a student needs to breastfeed, it should be covered by Title IX. Now the courts, it's a slightly iffier place, and just as the court has really ruled on this issue in a school-based setting, but we would argue at the National Women's Law Center that breastfeeding is covered, and that we really want to be aggressive on this front in terms of making sure students get those breastfeeding accommodations. And I have not said this, and is that for all of these things, with breastfeeding in particular, there might be protections. Don't just look to Title IX. That's what I'm focusing on and talking about, but there are often state protections as well that you can look to. So I just want to spend a few minutes on what negotiating and working with schools when you have a client before I turn it over to Galen, who's going to talk a little bit more about actual litigation. So one of the things that we find with the pregnant and parenting student cases, when somebody comes to us, it's kind of in the middle of things, right? There's been some kind of negotiation, things have already been happening, schools might have made some promises in terms of what they're going to do. And so a lot of things have happened before the student gets to us. And sometimes the discrimination has already happened and we're only kind of looking back for compensatory things, or sometimes we're in a position to really change things. But just kind of be aware that a lot of times, like I said, it's in the middle. It's already negotiations might have been going on for some time in terms of what the student needs. And there might have really been a lot of promises that were made. Sometimes a teacher might have made a promise that the teacher can't keep, or an administrator made a promise and then that thing isn't kept, or an administrator said something but then the teachers refused to follow it. So, or, there's lots of different kinds of configurations that can happen. And so I know this is true of everything, and anytime you're representing clients and you're doing this work, that you have to get all of the information down and make sure you have all of the materials and make sure you have all of the communications and that you've kind of gotten a straight story and that it's really clear. And I just want to really kind of say that, underscore how important that is in these pregnant and parenting student cases. One of the other things that you'll encounter is that both, depending on what age group you're working with, you might have parents who have talked to some people and have gotten something said while the student has talked to some people, or maybe there's been an advocate at the school, so a nurse has talked to somebody or a counselor has talked to people. And so there are kind of these multiple places where you want to make sure that you have all of that information. So once you've kind of made sure that you've got the whole piece and the story and you've pieced together what the promises are, and again, if there have been promises, there are things that have been said, you want to make sure that they're kind of in compliance and that they're ready for that those are things that would be in compliance with Title IX, because sometimes another thing that happens is that a student will think like, okay, they were kind of pushing me out of school, but now they've offered me this online alternative, so I think that's okay, I just want to do that online alternative. But really, when you sit down and you talk with the student, that's not at all what she wants. What she wants to do is be able to graduate from her school and do all the things she was planning on doing. And so don't let the school hold you to, well, she said it was going to be online, and so why can't she just finish this online? Don't let the school hold you to that. The students didn't know, their parents didn't know what all their rights were, and they can't just negotiate them. They can't write them away. And so just make sure kind of all of those pieces and that you're doing this deep dive with the students on what they really want versus what they're settling for, because that's kind of what the school said, and they didn't know when they first came in and started talking to them about what their rights really were. So once you've kind of done all of those things, and of course, and you've put all of the pieces together, you're going to, do kind of that formal communication with the school. So first, notifying the school that you're representing the student, and then coming up and doing your letter that lays out those promises, what was said, lays out those pieces, and lays out really very clearly what you are asking for and what you expect for the school. So my kind of second note here is kind of be prepared for the worst, but be open to surprise. So one of the things I've found in doing and working with schools, and again, I work with students kind of in a really broad range and work with schools in a kind of a broad range of settings. And so sometimes the Title IX violations are kind of small. It's like, well, you don't have a Title IX coordinator. And so once you tell the schools like, oh, you need to have a Title IX coordinator, they're like, oh, I didn't realize that. Or sometimes, there have been times where we work with a school and they'll look there like, oh my gosh, these policies, this nurse was following this policy that was from the 1970s and it wasn't updated, and so we are going, you are right, this needed to be updated. We never should have asked the student to do whatever it was. Like, in particular, thinking of a case where students were kind of being asked to fill out all these medical records and forms and get these kind of things that were again kind of not only in violation of Title IX, but also so outdated that they just didn't make sense. And it was really easy once these problems were pointed out to the school, they were quick and happy to fix them. And so that is not at all, and Galen's going to talk more about those cases where, where that's not what happened, but it can be. So, you want to be your negotiator, and you want to, be strong and be a good, zealous advocate for your client, but be open to surprise. Sometimes schools will surprise you and will be willing to work with you. A lot of times, I say this when I do presentations to administrators that, we're all in the same business. We want to help make sure girls are succeeding, and we want to make sure people are getting the best education for them. And a lot of times schools are coming from that, and there have been problems and there have been breakdowns, but the schools for the pregnant and parenting students can be more open. Again, I don't know, I don't want to sound too Pollyanna about it, but that, because we definitely also have the schools being like, no, we're not going to do this, and you are completely wrong and really not being good for the students, but there can be these opportunities and to go in. So if you aren't able to get a resolution, you do have options. Galen's going to talk about the option of going, of suing in court. Title IX does have a private right of action. You don't have to exhaust administrative remedies, so you can go directly to court. But you also have this option, which I said at the very beginning, of going to the Office for Civil Rights. And I have a question mark there because we would, we definitely want to continue to see complaints being filed, and I think the pregnant and parenting students, complaints are potentially more easily resolved than some of the other complaints. But we do, you do want to be strategic and thinking about whether or not the current Department of Ed and OCR are going to be the best place in terms of resolving your problems, and whether or not filing the complaint is going to help you as you kind of continue negotiating or not, because that, again, kind of a strategic call as to whether or not you think that filing a complaint would put pressure on the school to help resolve, or if you need to or if that's less likely to be helpful. So we have this list of helpful resources, so I'm not going to leave it up for just a second, but you will get an email of it, and you'll also get the email with this when you get the slides that will have my contact information. So I'm going to turn it over to Galen now.
Fantastic. Thank you, Kelly. That was a great presentation, and I am going to be elaborating a lot on what Kelly has already covered. So if we can just get my slides up, and you can go over to the next one, please. So just going to talk a little bit about, in more detail, about the types of cases that we've seen that have progressed a little bit further, and some of the legal theories that are available in advancing these kinds of claims. There has actually been relatively little litigation concerning pregnant and parenting students, and that's in part because so many cases are resolved prior to litigation. Many of the cases that we see are, concern outright violations of law that are very clear and violate the regulations that are longstanding from the Department of Education. So as soon as schools are made aware of those violations and kind of educated about the law's requirements, in my experience, they actually have a relatively high rate of coming around and doing the right thing. And that can make for quick victories for clients, which is great, but it does mean that there is not a whole lot of precedent out there in terms of legal decisions. So that's in part why presentations like this one and Know Your Rights materials by the National Women's Law Center and allies and the ACLU affiliates out there are such critical tools. There are also some obvious and significant barriers to pursuing litigation with this population, not least of which is that the impacted population obviously tends to have its hands full between school and raising a child or more than one child. So that can be a barrier to pursuing violations of these rights. So I'm going to be talking, as I said, about some of the common fact patterns and the legal theories so that those on the call can be aware of where the most solid litigation possibilities lie. If we could have the next slide. And wow, the slide is not looking right. I don't know quite how to deal with this issue. Folks, it looks like it didn't load correctly in terms of the formatting, because a lot of the slides appear like they are in the wrong font.
Is that looking better? I know that people can see more of the slide, but does that look a little better, Galen, or no?
I suppose it will do in a pinch, but it looks like somehow when I sent it, it didn't. Did you copy and paste it into a new PowerPoint, or how? I thought I had sent you a pictures file, so that would have avoided the formatting problems. But I suppose this will do in a pinch.
Okay.
But you're going to have to change the font on every slide. Yeah.
Okay. We'll try to pull up the file, but if you want to just proceed, I think right now we'll do our best to get the other one over.
Okay, all right. So Kelly talked in her presentation about the private right of action that exists under Title IX and the lack of any exhaustion requirements. That's just a threshold question. The Supreme Court has also made clear that damages are available as well as injunctive relief if folks are pursuing the private right of action. Another important note is that federal funding for part of an entity means Title IX liability for the entire entity, and this is established by statutory language, which was actually a legislative overruling of a Supreme Court decision to the contrary in Grove City College versus Bell. So Congress amended Title IX to make clear that liability for a part or receipt of federal funds for a particular program subjects the entire recipient to Title IX liability, and that's critical. In particular, it's easy to establish Title IX liability for public schools, for example, because it's clear that public schools receive the bulk of their funding from, or a significant portion of their funding from federal dollars. For private and charter schools, that might be a little bit more complicated. That looks better, thank you. That's my font. Okay, thank you.
Is that the right slide, or
yeah, that's correct. Yes, thank you. All public schools are covered, as I said, but private and charter schools might be receive federal funds only for a limited purpose, and that means that under this legislation, they are still subject to Title IX. So, for example, accepting federal funds for the school lunch program, which many even private schools receive federal funds for school lunch, would subject the entire school to Title IX liability. And at the university level, this can also make a big difference because universities, non-state universities, private universities, nonetheless receive federal dollars for a variety of purposes, and that subjects the entire university to Title IX liability. I'll also mention that there are other claims that can be brought. Kelly mentioned state law claims. I'll also mention constitutional claims if you are in the public sector. So if you are in a private, rather a public school or a public university, Section 1983 equal protection claims can be brought and are coextensive, and the Supreme Court has held in what was actually a unanimous opinion by Justice Alito that Title IX is not meant to be the exclusive remedy for sex discrimination in education. And this is really important in part because the remedies can be different. For example, there's individual liability under equal protection where there isn't under Title IX. That's just one example. And I'll just make one more note, which is that some religious schools are actually exempt from Title IX if they have sought an exemption because it conflicts with their religious beliefs. And there is actually a list of those schools that have sought and been granted that exemption. The list is on the OCR website. Still, it is marked as archived recently, but it is still there, so you can see that list of schools if you have questions about whether a school that's religious or religiously affiliated has sought and been granted an exemption. Could I have the next slide? So I'm going to talk a little bit about some of the earliest cases that were litigated around these issues, and those arose in the context of the Honor Society participation in activities like the Honor Society. And those cases arose where you saw cases where pregnant students were not permitted entry into the Honor Society despite meeting all the other criteria. One case that I've highlighted was an ACLU case filed in Eastern District of Kentucky, which is Chipman versus Grant County. There's another couple cases that are cited on this slide. In one of the cases in Cazares versus Barber, the father of the child was actually accepted into the Honor Society, but the girl who gave birth was denied entry. So you can see a very clear-cut case of sex discrimination, disparate treatment on the basis of sex, which is, of course, impermissible under Title IX. And then the Third Circuit in Pfeiffer actually remanded the case to consider evidence that a male student had had a baby out of wedlock. So in looking at these cases about denial of equal opportunities to participate in activities, you should be looking for comparators, male students who were treated less badly, who were treated differently. Note that these cases do use a sex discrimination theory rather than a pregnancy discrimination theory. They're not saying that discrimination on the basis of pregnancy is unlawful under equal protection. And that is because the Supreme Court had previously held in Geduldig versus Aiello that pregnancy discrimination is not sex discrimination for purposes of an equal protection analysis, as long as the scheme isn't essentially used, as long as pregnancy is not a pretext for invidious discrimination. So there is a little bit of wiggle room there in that language regarding pretext, and for that reason we have in some cases brought equal protection claims on the basis of pregnancy, but that is just an obstacle that is still out there and that requires some creative pleading and working around in order to make out equal protection claims. But that said, the Title IX claims are very clear. And I'll also just mention that another of the theories that are used in these cases are sex stereotyping theories, essentially that exclusion of girls, pregnant students from participation in activities reflects and reinforces a sex stereotype that parenting is incompatible with education and that girls who are pregnant really belong at home with their children. And it, of course, also, these types of cases on exclusion from activities or from educational programs do reflect the additional stereotype that girls who are sexually active are less acceptable and more shameful than boys who are sexually active and are deserving of some sort of punishment or exclusion. So that's just a theory that I wanted to raise up. If I could have the next slide. So talking about exclusion or push out of pregnant students, that's a common theme that we see, a common fact pattern, and as Kelly mentioned, it comes up frequently. Just one case that I'll mention that the ACLU did work on, it was Hicks versus Wingate Elementary School, and the plaintiff was a student at a Bureau of Indian Affairs school who, when her pregnancy became known, was told that she couldn't continue to attend the school because she would set a bad example. And she was only allowed to return to the school after the ACLU intervened. So our demand letter got us halfway there. But in that case, shortly after she was allowed to return to school, the school director actually called out her name at an assembly and stood her up and announced to the entire school that she was pregnant. So in that case, obviously, you're dealing with a case of humiliation and the kind of hostile environment that Kelly talked about earlier. And we did sue, and we brought claims, Bivens claims, based on equal protection and violation of the right to privacy based on sex and gender. We also brought Federal Tort Claims Act claims. Note that we did not bring Title IX claims in that case, in part because the school itself was an arm of the federal government. The Bureau of Indian Affairs is an arm of the federal government, so there was case law that suggested that we could not bring a Title IX case against a BIA school because BIA is not itself a recipient of federal funds under Title IX. And that case actually was dismissed in part because the court did not want to extend the Bivens claim in that case, and it did settle on appeal to the 10th Circuit. Could we have the next slide? Kelly was talking about archaic policies, and this case is an example of just such a policy. This is a charter school in Delhi, Louisiana, that basically, if students were suspected of being pregnant, they were required to take a pregnancy test with a doctor of the school's choosing. And pregnant students were required to pursue a course of homeschooling, in other words, pushed out. And those who refused the pregnancy test were interestingly treated as pregnant and required to pursue a course of homeschooling or, quote, counseled to seek other educational opportunities. So you can see that these are not very artfully coded references to essentially forcing girls out of school. And that case was resolved quickly upon receiving a demand letter from the ACLU. If I could have the next slide. The next slide is actually just a picture of that actual pregnancy policy in case it sounded too crazy to be true. There's the evidence. Okay, next slide. So unequal education opportunities, Kelly mentioned the pregnancy schools, and in that case in New York City, the NYCLU and many, many allies did a lot of advocacy to bring about reforms, and which resulted in the P schools being closed. But the issue was actually litigated in California, and this was a case filed in 2005. It's known as the CalSafe Cecilia G. versus Antelope Valley case. The California legislature had enacted a program called CalSafe, which stood for California School Age Families Educational Program. And in Antelope Valley, the way that was implemented was that there were 3 campuses where sort of alternative pregnancy schools where pregnant students were sort of warehoused and provided there were no teachers providing any oral instruction. It was basically a complete warehouse with they were given some reading and they were given some worksheets and things like that. And that case was challenged and survived a motion to dismiss and later settled. And in that case, we brought equal protection claims primarily, as well as Title IX claims. Could I have the next slide? I want to mention truancy policies. I know I'm reaching the end of my time, but truancy and attendance policies, there's another lawsuit that was filed by the ACLU of Pennsylvania and the ACLU Women's Rights Project challenging the application of a state statutory absentee policy for as applied to students with child care and parenting obligations. Students under that statutory scheme were granted excused absences for reasons like farming, domestic service, and educational trips, but not for reasons related to parenting. And so we challenged that and brought claims arguing that refusing to excuse absences related to parenting obligations violated students' due process rights to parent, and also Title IX claims based on disparate treatment and sex stereotyping theory about motherhood being incompatible with education. And that case also settled after filing. It didn't result in any court decision. Okay, next slide. I'd like to talk a little bit about the opportunity to make up coursework. Can we advance the slide? Thank you. There are actually quite a few slides on this because this is an area where there has been a good deal of litigation. I'm sorry, go back one. Thank you. So I just want to mention Hogan versus Ogden, which is probably I think one of the best cases on this. The plaintiff there was a pregnant student at Central Washington University who was in a video production class, and she actually had a perfect attendance record until she was ordered on bed rest because of pregnancy complications. So she was able to keep participating and meet the coursework requirements in other ways, but the professor rejected her proposals on how to do that and advised her instead to drop the class. So this is a fact pattern that you see often play out at the high school level, middle and high school level, that here we have an actual case on it. And so she filed claims under both the ADA and the Rehabilitation Act for disability discrimination, as well as Title IX and equal protection claims and state law claims. And the court held that there were sufficient fact questions to survive, I believe it was summary judgment motion. The court's ruling on the equal protection claim was overruled later. In that case that I mentioned earlier, Fitzgerald versus Barnstable School, the court here had held that there was no equal protection claim because Title IX was the exclusive remedy. So that ruling was overruled, but the rest of the rulings are good law and are a good resource for folks who are dealing with refusal to accommodate and find alternative ways to complete course requirements. Okay, next slide. I also want to talk about a little bit about Conley versus Northwest Florida State, which is a recent Title IX decision and a really good one. So the plaintiff in that case was a student in a college EMT program and was required essentially to certify that she was even fit to participate as a pregnant student. And then when she later had some pregnancy complications and was placed on bed rest, she was excluded from her clinical rotation due to potential liability regarding her unborn child. And then she was dismissed from the program and given an incomplete. And the administration refused to let her finish the clinical rotation or take her finals before the next semester. So there was an admission on the record that she would not have been admitted if they had known she was pregnant. And she was admonished for taking risks. And the quote is, she had messed in her nest, which is one of my favorite ways of putting this. So she had messed in her nest, and the court held that that Title IX's prohibition on sex discrimination encompasses pregnancy. It's an explicit holding on that point, and that the Department of Education's regulation on that point, which Kelly covered in the first part of the presentation, is entitled to deference under Chevron. So that's actually really, really helpful holding in this case that can help you overcome any kind of arguments that Title IX, because it doesn't say pregnancy or include an explicit definition of sex as including pregnancy, still properly should be interpreted to encompass pregnancy discrimination. All right, next slide. Just a couple cases dealing with a pretext issue. This is actually an older version of the slide, but these are both, the title of the slide should say pretext here, not missed coursework. So just a couple of kind of contrasting ways that courts have handled the question of whether the school's intention is discriminatory, whether their motivation for their actions is pregnancy or other non-discriminatory reason. So Ivan versus Kent State is a not great opinion in that the court granted summary judgment for a university, even though the plaintiff had been she had alleged that she was subjected to extra monitoring and received poor grades after she gave birth because the court found that the university had produced a legitimate non-discriminatory reason, which was related to her performance. But of course, she'd been essentially alleged that she was targeted because of her pregnancy. So in this case, the court did not really look to a pretext analysis. And then in Francola, the plaintiff was a med student with a bipolar disorder who had taken a medical leave, and then she was told that she needed, in order to be readmitted, she needed to just submit a fit for duty letter. But when she did so, she was actually denied readmission. So this goes to a violation of the school's obligations to allow the student to pretty much pick up where they left off, restore the student to the same status they had been in before they gave birth, and that was the violation here. And in this case, the court held that there was sufficient evidence to survive summary judgment. So just quickly on the OCR process, if I could have the next slide. I want to mention a great National Women's Law Center case that this was actually a case brought against Borough Manhattan Community College, where the college had no policy on missed coursework and absences, and left it entirely up to individual faculty. And there was actually a professor of anthropology course called Roles of Women, the irony there, who refused to let a pregnant student to make up tests that she had missed during her pregnancy, and she had to withdraw from the course and the scholarship program, and she suffered from retaliation. So this was a OCR complaint that was brought by the Law Center, and it resulted in a wide-reaching settlement that applied across the CUNY system, including compensation for the complainant, a new policy that was compliant with Title IX, training, and they've obtained similar results in at least one other case filed against a high school that refused to provide homebound instruction. So you can see that OCR was in this case a great resource. It can really bring about systemic reform, and you know, when the informal resolution attempts are not successful. And I'll mention just in terms of pros and cons that OCR complaints don't require as large an investment of time and energy as litigation does from either the complainants or their attorneys. So it's a really good thing to consider because of that. And you can see that the reforms that were achieved through this kind of brought them further than a lot of the litigation, which has, you know, either not been brought to fruition, although in many cases settlements were reached. This is really broad relief. So it was a great outcome. The cons of the OCR process, though, I'll mention. The process can be painfully slow, and many complainants actually graduate before resolution is achieved. So you shouldn't go into it expecting that it's going to be that much quicker than litigation, because in many cases it is not. And then the attorneys also have, I think, relatively little control over the process. Once you hand it to OCR, they do their investigation, and it really varies how much you are kept in the loop. And I will say my experience has been not as much as I would have liked. So complainants can be, you know, sort of not particularly empowered by that process, and it can feel a little bit out of your control in a way that litigation doesn't as much. And, you know, the current political environment being what it is, as Kelly mentioned earlier, it's really unclear how these cases now will be handled in this administration. We know that there are many in OCR, many staff who are dedicated and who continue to want to do the right thing, so we can only hope that they're given the tools to do so and to really continue to conduct robust investigations and enforcement efforts. But I think that is the question mark that Kelly put on her slide is very much a reality. So if I could have the next slide, just a couple of other legal theories that are a little bit less well developed. I want to mention just that don't overlook the ADA. Pregnancy complications can be considered a disability under the ADA and the Rehabilitation Act, although normal pregnancy is not. And that is even more true in light of the amendments of the ADA, which took place a few years back. So that really expanded the pool of individuals, and also it expanded the pool of individuals who can be used as a point of comparison, because Title IX does, and the regulation does, specify that pregnant students should be given the same types of accommodations as students with temporary disabilities. So that built-in comparator is there, and the pool of people who are comparators has grown in light of the ADA amendments. And I think I will leave it at that because we are short on time. So I think it's now Alexandra, do you want to take questions?
Absolutely. Thanks so much, Galen and Kelly. I know that I learned a lot from that, and I'm sure that our participants did as well. We've received a couple of questions, and so we'll run through those quickly here. So first of all, on this topic, do you have any identified best practices for empowering pregnant and parenting students to know and understand their rights early in their pregnancy? Community education brochures, online KYR sites, and why don't we start with that?
Sure. Well, a few of the resources were actually on my last slide. So there is actually a really great guidance that the Department of Education put out a couple years back that kind of elaborates on what the regulation means and puts it in plain English. And that's a really, really great resource. A lot of organizations have put out Know Your Rights materials, and some of those are also listed here, including, of course, the Law Center and the ACLU. So those are included here. And then Title IX coordinators are also a good resource that's sort of untapped, that each recipient of federal funds is required to designate a Title IX coordinator, and those folks, it varies somewhat in terms of how educated those folks actually are about the scope of Title IX's requirements, but there are Title IX coordinators out there who are incredibly well educated about the rights of students, and so that's an additional resource that I'll mention.
And I would just kind of echo on that similarly, my last slide has resources, I think, that very much overlap with Galen's recommended resources as well. And in addition, which isn't perfectly on your question in terms of resources, but we have been developing a model policy for schools that would go somewhat beyond what is required by Title IX, but really the a best practices for working with pregnant and parenting students. And part of that best practices is really includes this education piece, so that the information we would like to see from schools, make sure that they have put the information for pregnant and parenting students should be in their student handbook and kind of in a place that's accessible, that students who are pregnant or parenting would look at and see and find that information, and that you educate your teachers, not just the Title IX coordinator, but that teachers are particularly first points of contact for students who are pregnant or parenting would have, so nurses in particular, school educators, like those kinds of people, guidance counselors are aware of what the rights are and what the processes are, because again, kind of, what is homebound instruction, and making sure that students, that the administrators know and the people they're in contact with know about it and can then provide and pass on that information. And so that's part of kind of our best practices for schools that we would like to see, which is really this, broad-based information, so that students are notified proactively and affirmatively when when they tell and notify their schools of their pregnancy.
Thanks. Okay, so we've gotten 2 questions so far on religious schools. So maybe we'll join these into one. So the question is, for the religious exemption for private schools, do K-12 private voucher schools that receive federal funding through Title I or the school lunch program need to apply for the exemption, or is that just a requirement for post-secondary institutions? And then I'm going to add on to that, what advice would you have for challenging religiously affiliated schools to justify treating pregnant students differently based on religious beliefs? So I know that's a lot.
So the question was, does it just apply to secondary institutions, or both post and primary and secondary?
Yeah, so I understood the first question to be, do K-12 schools also need to apply for an
apply for a
exemption?
religious exemption? Yes, if they receive federal funds. I guess my experience has been that not as many religious schools receive, religious K through 12 schools receive federal funds. So they don't have Title IX compliance to start with, but if they do, then they would need to seek that exemption, and that exemption is available to them.
And then do either of you have any advice for challenging religiously affiliated schools' practices that treat pregnant students differently?
There can be claims under state law in some cases, and I would say that sometimes there are contract-related claims, but definitely the claims are constrained in that context. There are fewer options.
So I would add that again, Title IX does follow. There is the funding aspect, and I mean it's kind of a complicated kind of question in terms of, again, because then you would need it anyway. Just to say that don't completely close out if they are receiving federal financial assistance, they are receiving some kind of federal funds. To investigate that piece as well, to see if there's if there is potential Title IX claims. And Galen said, contracts, if they have agreed to do something, they need to be held accountable for whatever, teaching they have said they would do, and that can be another way to get to those schools. And sorry, I had something else to say and started to forget it. But one of the other pieces that I will say that it's not the topic of this particular webinar, but we are really thinking about what are our state laws and state policies that we can use, and what are model policies to make sure that all schools within this state that all students and that all schools are within a state are covered by protections. And so there's kind of that advocacy route as well to try to get that coverage.
Great, thanks. So I know we have a lot of questions. Maybe we'll take one or two more and then sign off, because I want to be respectful of everyone's time. A question, are there Title VII cases that have addressed lactation issues as part of pregnancy discrimination that could be used by analogy under Title IX?
Yes, there are. So the lead case is EEOC versus Houston Funding out of the Fifth Circuit. That case was the first case, circuit court decision, to hold that discrimination on the basis of lactation is prohibited under Title VII. And the lower courts have, since that case was decided, essentially adopted the reasoning of that opinion. So I would say, but prior to that, the case law was not good on whether lactation was covered, and you even had one court it was actually in the lower court EEOC case, holding that lactation was not a medical condition related to pregnancy and childbirth. And the Fifth Circuit did reverse that, and that really did reverse the trend. As I said, now I think the tide has turned, and courts are more and more recognizing that Title VII does, the prohibition on sex discrimination does extend to discrimination on the basis of lactation. And we have cases pending, the ACLU have cases pending in making that same argument in the Title VII context, and we are interested in making that argument in the Title IX context, but haven't yet filed any cases. So if you do hear of anything or want to discuss it, I would make myself available as a resource on that.
Okay, great. We've got one short one, and then we'll wrap up. I just wanted to ask, how can you find out if a private school accepts federal funding that would make it subject to Title IX? Is there a list somewhere?
There's not a list per se. Usually schools have financial reports, so you can find their financial reports, and they will have a budget line. Sometimes you can find that out from federal agency websites. like the Department of Agriculture, or there are various grants that are given to schools for particular purposes, and some of those agencies list the grantees, the grant recipients on their websites. So it can be a bit of detective work that is required in the context of private schools to establish federal funds.
Yeah, and you can, I mean, in addition to going to the federal sites to look for funding, also look at the programs that the schools participating in. You know, if they're advertising, we do this or we do that, you can find these programs and then kind of backtrack a little bit to see if those programs are federally funded. But it does, yes, it can be that kind of detective work in terms of where they are receiving their funding.
Great. Well, thank you so much, Kelly and Galen. I know that we didn't get to some questions, so I'm going to rudely volunteer Kelly and Galen. Their contact information is in the presentation. You know, I really, again, just want to thank our presenters and all of you for joining us. Before I hand the phone off to Nia for some internet logistics, I wanted to really encourage you all to join our Legal Action Network. I'll be circulating, or Nia will be circulating a link to join. And that's a way for you to let the Law Center know that you're interested in taking on sex discrimination clients in schools and workplaces, in healthcare, and we are in particular need of attorneys who feel comfortable taking on pregnant and parenting students as clients. So we really do hope that you will sign up, and we will continue to offer trainings and resources. So thank you all again, and Nia, take it away.
Great, thanks. Just want to echo what Alexandra said. Thank you all for joining us. Thank you, Galen and Kelly. I know this is the first of many conversations. I just want to remind everyone that we did record today's session, and I personally will be following up with an email that includes the recording, the slides, and as Alexandra mentioned, the slides contain the contact information of both Galen and Kelly, and we'll also have a link in there that will allow you to join our legal network. So thank you again for joining us. We look forward to the next conversation. Have a good day.